for attending the second Intercollegiate Undergraduate Law Review Conference. On behalf of the Fordham Undergraduate Law Review and Fordham Undergraduate Law Review Editorial Board, we would like to thank the respective journals and especially the editors-in-chief of the Boston Pre-Law Review, Columbia Undergraduate Law Review, George Washington Undergraduate Law Review, and Virginia Undergraduate Law Review for their enthusiasm and cooperation in helping organize today's conference. Furthermore, we would like to give special thanks to our keynote speakers, the Honorable Desmond Lyons, Caroline Morris, as well as all of those who were nominated to speak on behalf of their journals and that are going to be presenting their work today. Without all of your willingness to be here and dedicate your time to this conference, it would not be possible. Regarding undergraduate law reviews, within the past 10 years, the number of those incorporated has rapidly increased. Within the time that the Fordham Undergraduate Law Review, FULR for short, has been in existence, approximately only 3.5 years, we received communication from various other undergraduate members of pre-law communities who were seeking guidance in developing and incorporating their own undergraduate law reviews for their respective schools. We understand that this has been true for various other undergraduate law reviews as well, who has also served in mentorship roles to the new and burgeoning undergraduate law reviews. In recognition of this, last year, FULR decided to organize and host the first Intercollegiate Undergraduate Law Review Conference. The goal was to create a space where information could be shared and that it could pave the way for innovative and fruitful legal discussions. There were a number of presentations last year that sought to address contemporary legal topics in a way that was wholly unique to the author who was presenting them. This was all due to the willingness of pre-law students to devote significant portions of their time to writing and editing legal arguments, which, as you all know, is no small feat. Following the first Intercollegiate Undergraduate Law Review Conference, the FULR received feedback that participation in the conference inspired new writers to pursue writing for their journals and also inspired experienced writers to tackle complex legal issues that they previously felt ill-equipped to address. Based on this, as well as the rapidly expanding community of undergraduate law reviews across the country, FULR once again decided to host the Intercollegiate Undergraduate Law Review Conference. We believe that this conference has led to the development of a community where the future of the legal world's brightest minds can begin their journey at the undergraduate level. Today, we will hear from the importance of fostering legal thought as soon as possible and its role from the Honorable Desmond Lyons. We will then gain a more nuanced understanding about how being part of an undergraduate law review directly benefits students on their law school journey with Caroline Morris, a UVA law school student and emeritus co-editor-in-chief of the Fordham Undergraduate Law Review. We will then hear from a variety of highly intelligent authors from all of our respective undergraduate law reviews about their nuanced approaches to the law and the legal topics which they sought to address. Despite this conference only being approximately 2 hours, the wealth of information that will be presented today is going to be invaluable to all of us. I would like to thank each and every single one of you once again for the time you've taken to be here today. As my final thoughts, I would like to leave each of you with a reminder that what we do is extremely important in fostering development within the legal community. As we've seen in recent years, our collective success as an undergraduate law review community reflects this in every regard. We will now transition to our first keynote speaker, the Honorable Desmond Lyons, for his presentation on judicial independence and the role of lawyers. Mr. Lyons, could you please give us a quick biography about yourself before you begin your presentation?
Sure, and thank you, Jonathan. First, before I do that, I just want to thank both Jonathan and Thomas for the invitation to appear today. I really appreciate it. I'm honored to be here. It's been a pleasure to get to know Jonathan. Was one of my students in my legal frameworks class, and that's how I first met Jonathan at the Gabelli School, where I teach in law and ethics. When I'm not teaching at the Gabelli School as an adjunct, I'm a full-time lawyer and a part-time judge in New York. My role as part-time judge in New York puts me in a unique position to, come across litigants from all walks of life, see good lawyers, see bad lawyers, and puts me in a position where I have to make decisions in the gray area, and that's where cases are won and lost as a lawyer. And I see that as a part-time judge, it makes me a better lawyer as well, because I do get to see so much as a judge. I am also a partner and a founder of a prominent Westchester County law firm where I've been for more than 25 years. And in that capacity, I do commercial and civil litigation of all different types. So I frequently find myself in federal and state courts and appellate courts as well. I have litigated and tried cases in virtually every venue there is, from small local court to the Court of Appeals Second Circuit. One place I have yet to argue, and I hope to get there one day, is in the United States Supreme Court. But the Court of Appeals in the Second Circuit is pretty close. So I thank you again for inviting me. Congratulations to you all on putting together this amazing conference, really, really amazing conference, and especially to the members of the Fordham University Law Review for your work on putting together that law review, which is a really important publication and a really high level publication that I think can compete with some, quite frankly, some law school law reviews. So you guys are doing a great job. So keep it up. If I can be of any assistance, as you know, please feel free to reach out. So my remarks today, as Jonathan alluded to, concern the role of the courts, judicial independence, and the role of lawyers in preserving that judicial independence, and the importance of that role for lawyers. And I'm also going to extend that to law students and those in the pre-law arena, and your role and how important it is for you all to explain the role of the courts and explain the importance of judicial independence. We've seen recently, even in New York State, in the Court of Appeals in the top court, there's a battle over who was going to become the chief judge. And it got to be very political, which is not unusual, but it's unfortunate. So I'm going to address my remarks are based on a lecture I previously gave and an article that I wrote in a journal, a legal journal in Westchester County. And again, it's entitled Judicial Independence. It's called The Enduring Importance of Judicial Independence. So I'll begin. So given the bitter divide in our country and the likelihood of many consequential issues winding up in litigation, it's vitally important for the public to understand the essential purposes of our courts and the roles that the dedicated professionals play in them. Okay, and it's equally important for lawyers and judges to tirelessly defend the rule of law. Again, I'll extend that to law students and those in the pre-law area. To tirelessly defend the rule of law and judicial independence. As the late Justice Ginsburg reminds us, courts depend on members of the bar to explain to the public the importance of an independent judiciary and to protect it with vigilance. It's up to members of the bar to educate the public on our court's work and why judicial independence remains an existential imperative. Now, in a recent speech delivered to the Westchester County Bar Association, former Chief Judge of the Southern District, Colleen McMahon, warned of the threats to our legal system from a loose connection to facts, from truthiness, as she called it, and alternative facts. Judge McMahon exhorted the judges and lawyers present to defend the Constitution by rededicating ourselves to our mission as vigilant guardians of the facts and the rule of law. Judge McMahon observed courts today are under withering pressure from outside influences, and not only in Washington, where battles are waged over federal judges and Supreme Court vacancies, which you see in the news, but throughout the country. Today, there are more than 30,000 state court judges and more than 1,700 federal judges, not to mention tens of thousands of local and municipal court judges who preside over courtrooms like the one in which I sit. Every day in these courtrooms, judges are called upon to make difficult decisions involving complex facts and often equally compelling interests. My colleagues and I are not Democrat judges or Republican judges or Biden judges or Trump judges or Obama judges, but rather professionals who work hard to adhere to our oath, to be true to the law, and to deliver fair and impartial justice. Recognizing that our decisions have a direct and meaningful impact on the people and families that appear before us, we work to ensure the integrity of the process so that litigants are able to trust the decision was arrived at fairly, no matter the outcome. And while we are far from infallible, and admittedly, progress remains to be made in a number of areas, our efforts remain focused on reaching a just result, even if that result at times fails to meet with popular approval. The perception that judges make decisions based on personal policy preferences rather than the facts and the applicable law not only impacts our highest courts, but has a trickle-down effect on lower courts, and it slowly erodes the legitimacy of those courts. Members of the bar and the bench, as well as law students and pre-law students, must meet the challenge laid out by Justice Ginsburg and others by tirelessly protecting our courts and defending judicial independence and noting the importance of the rule of law. As Judge McMahon noted in her lecture, our republic may well depend on it. And with that, I'll leave you with that note. Unfortunately, I have another engagement, so I can't stay for the entire conference. I'd love to be here for the entire conference. I do thank you for having me. I can stand by if anyone has a couple of questions. I'd be happy to answer to the extent I know the answer. But like a good lawyer, I can dodge pretty well if I don't know the answer. So feel free to ask away if there is any.
Great. Thank you so much, Judge. We really appreciate that. That was an amazing talk. It looks like we're good. I don't know if you're getting any personal questions right now in the chat. I don't see any as of the moment. But
in the chat, nope. I see Thomas's note to feel free to share any questions in the chat. I don't see any. I do really appreciate it. Again, congratulations to all of you for all your work on this. And Caroline, good work. I got to meet you once, I think, at the I guess the sort of the pre-law kind of networking session a while ago.
Great to see you.
Nice to see you as well. I trust everything's well down at UVA. How could it not be, right?
Everything's great at UVA, yeah.
Great. So congratulations to everyone. If anyone has any questions, you can always reach out to me. Jonathan, feel free to share my Fordham email with anyone who needs or has any questions at any time. Thanks again, everyone.
thank you, Judge. We really appreciate that.
I'll stick around for Caroline's remarks because how can I not? Another keynote speaker goes.
Of
But then I have
course.
to jump off. So thank you.
Of course. All right. Now we'll be transitioning to our second keynote speaker. It's Caroline Morris, a current UVA law student and co-emeritus-in-chief, a co-emeritus co-editor-in-chief of the Fordham Undergraduate Law Review. Caroline, if you could give us a quick biography before you go into your talk, it would be greatly appreciated.
Yeah, hi. Hi everyone. Congratulations for being selected for this conference. I'm Caroline. I'm a first-year law student at UVA. I graduated from Fordham last year. I studied international studies and poli-sci. This year at UVA, I've been doing a lot of pro bono volunteer work on a lot of asylum applications, part of American Constitution Society, and I'll be working at the Department of Justice this summer in the commercial litigation branch, national courts section, which does government contract and international trade disputes, and that's in DC. So yeah, I'm just going to talk a little bit about how I felt being part of an undergraduate law review has helped me in law school. And I think the first thing to keep in mind is like why law reviews and publications in general are important. So I'll just share a little anecdote. Last semester, I was working on a pro bono case for an asylum application for a gay man from Mexico. And we were claiming that he had fear of future persecution if he would return to Mexico. And essentially, we were making some pretty novel arguments about some more complicated facts of his case. And we've relied really, really heavily on one law review article that pointed us to a couple unreported cases and different training documents. And it just pointed us to a lot of sources that I don't think that we would have found otherwise. And we won his case. And there's really nothing better than the immigration judge saying that she's granting an asylum case. It's just very satisfying. It's satisfying to work with the client and feel like you have secured the client's safety in the United States. And it was just really exciting. And I don't think that we would have really won the case without finding the law review article. So with that, like, how does that apply to undergrad law reviews? I think first, all of you are potentially interested in going to law school in the future. And writing is so important in law school. Pretty much everywhere that I interviewed for summer jobs, for pro bono cases, pretty much anything you want to do in law school, you have to be a strong writer. And pretty much every institution in the law school really values strong writers. And I think publishing something in an undergrad law review not only signals to other people through your resume or your cover letter or interviews or anything that you're a strong writer, but it also actually does, I feel like, make you really think about how all of the pieces of evidence and how different arguments fit together, kind of like a puzzle where you have to fit each piece together. And it's really hard to go through law school and not kind of see how different arguments fit together. I think that even just going through classes and reading cases and stuff like that, it's just everything really hinges on how good of a writer you are and how easy it is for you to kind of pick up arguments and see how things fit together. And I think that going through the writing process of figuring out what topic you're going to write about, researching these topics that you've never really heard about, trying to find legal sources, it all just really contributes to all of the strengths that make someone a good law student. I've also personally found, I wrote an undergrad law review article on the severability of the individual mandate from the Affordable Care Act. And I've found that having the introduction to some vocabulary and concepts relating to law has really helped in law school. So like when you get to your first like civil procedure class or contracts class, sometimes it's difficult, like it's a difficult learning curve at first, to figure out exactly what all of the professors are talking about. There's a lot of vocab and terms and phrases that just aren't super intuitive. And I think writing on some area of the law that you're interested in can get you some really good exposure to different concepts early on. And then you can also kind of figure out what you're interested in. At least at UVA, I think a lot of other law schools do this. You have pretty much your first year curriculum structured and your classes are chosen for you. But then the second 2 years, you're pretty much on your own to choose all of your classes. There's really no required classes, so you're pretty much just filling your schedule based on your interests. And there's not a whole lot of time first year of law school to figure out exactly what you're interested in. So I think it's great to have the exposure before coming to law school about topics that you might want to explore more or things that you're definitely not interested in. And then I guess the last thing is having an undergrad law review publication. It's really something unique to put on your resume, to put on your personal statement, to talk about in interviews. And like when you go to if you're going to a law school, like everyone did well, like in undergrad, and everyone kind of has all of these great things about them. It's hard to kind of stand out. Like it's hard to, like everyone has cool things about them. And I think that the undergrad law reviews it's one of those small things that I think could be really unique. And personally, like in a lot of interviews, a lot of people have asked about it. And I think it shows like one, that you're a good writer, but also two, that you can manage your time well, which is difficult in law school. It's very busy. And I think it just is a really great talking point in interviews, which is just sometimes, I mean, I'm going to start interviewing for law firms soon. And my private practice counselor told me that some interviews can last up to 3 hours. So you definitely need things interesting to talk about. And I think that this is just such a unique thing to participate in. So yeah, I guess that's it. If anyone has any questions, I'd be happy to answer any questions about law school or preparing for law school or anything like that. But John and Tom can definitely share my contact information as well. So yeah, that's it. Thank you for having me.
That's wonderful. Thank you, Caroline. Very insightful points regarding the law school application process and undergraduate law reviews in general. Again, if you guys have any questions, please feel free to ask them in the chat. Caroline shared a variety of information there. Please don't feel restricted in what you can ask about. She's a wonderful resource in terms of both managing and founding law reviews and in that process of elevating our journal. But in addition to that, I mean, such a wealth of like experience in terms of internships, interviewing. I really recommend. She's a wonderful resource. But it looks like Nick Suit has a question. What was the biggest challenge for you going from undergrad to law school? If you want to tackle that, Caroline.
Yeah, I think the most difficult challenge, I think, was the amount of reading that was absolutely necessary to do in order to like survive in class. I feel like in college, like we get a lot of reading, and sometimes it doesn't feel super necessary to do all of the reading or to do it super in depth in order to get kind of like what the professor is trying to talk about in class. In law school, it's pretty difficult to stay afloat without doing all of the reading, especially if you're cold called in class. Essentially, cold calling is like the professors don't really rely on participation in class. They just walk into class and call on someone randomly and ask them questions. I guess that was one of the biggest adjustments as well. But I think it's just important to keep in mind that like everyone in law school is kind of in the same boat, and everyone is going through the same fears of being cold called and talking in front of people. And it gets easier as time goes on. So yeah, definitely don't some people I feel like let the cold calls like deter them from wanting to come to law school. It's really not terrible. And if it is terrible, everyone forgets about it the next day anyway. Someone else asked a question about the application process for the law review and how law students can prepare for it. Yeah, that's a good question. So I think it's the same at most law schools, but I can I only have the experience of UVA's law review application process. So essentially, second semester 1L year, which is what I am right now, we did a writing competition. So basically you have 8 hours to do a blue booking component, edit a paper that uses blue book citations, and you just have to go through and make as many edits as possible in 8 hours. And then we had 48 hours to read a packet of information, some cases, some law review articles. It's about like 200 pages, and then write an 8-page paper on it. And then the law review and all the specialty journals, like the Journal for Criminal Law, Journal for Social Law and Policy. Each law school kind of has like a bunch of specialty journals. You kind of, I guess they take like a holistic approach to certain applications. And then for some applications, like they just take like the top 10 people in the class. So they take into consideration grades, your personal statement, your writing, and your editing. And then you get offers, I think, end of April through the summer. So I've gone through the application process for the journals, but haven't heard back from any of them yet. Fingers crossed that I'll get on one of them. But yeah, how can students prepare for it? I think, I mean, I know the Fordham Undergrad Law Review uses Blue Book citations. That was like the biggest advantage for me, was having the exposure to the Blue Book citations. But other than that, there's nothing that you can do. It's a difficult weekend, but otherwise you will survive and it will be okay. Yeah.
I think, I'm sorry, I don't mean to cut you off. I know there's a few more questions in chat.
I can answer like via chat.
Yeah, if you wouldn't mind, I think that'd be perfect. Okay, but thank you so much, Caroline. You had some really amazing insight, and it feels very good to know that the fact that what we're all doing and all the time that we spend on, our respective undergraduate law reviews really ends up having a meaningful impact for those of us, not only who want to go to law school, but it seems like who go into the field of law in general. Okay, so.
Wonderful. All right,
Yeah.
Thank you. Again, we'll be wrapping up our keynote speaker portion of the presentation. Thank you again for Judge Leons and Caroline for your wonderful insights. If you guys continue to have questions, please feel free to ask them in the chat. I'm sure they will do their best to respond. But from this point on, we're now going to be moving into the note presentation portion of the conference. So as we've kind of presented in our materials, there's been 10 writers who've been selected for their exemplary and notable submissions to their own undergraduate law reviews that have been selected for today. Please, you should be proud of what you've done to get to this point. All of your peers have decided that you and your submission was of a higher quality and definitely deserves celebration. This conference is more meant to elevate and showcase what you've done. For the 10 writers, we'll be beginning with the Boston University Pre-Law Review with 2 writers, Aaliyah and Shreya. We'll begin with Leah, if you're good to go.
Yes.
Wonderful. We'll let you take it away.
All right. Hi, everyone. My name is Aaliyah Destiny Rodriguez, and I am a student at Boston University, and I'm so honored to be here. So thank you for having me. Today, I will be discussing the article that I wrote about Act 60 in Puerto Rico. Act 60, known as the Incentives Act, was implemented in Puerto Rico in 2020, but actually stems from a combination of Acts 20 and 22, which had originally been enacted in 2012. So you may be wondering, what is Act 60? Act 60 offers tax advantages, savings, and other incentives for investors and businesses introduced under the pretense of improving economic development in Puerto Rico through tax credits. However, there has been a significant amount of controversy surrounding Act 60 and doubts regarding its efficiency. Concerns have been about such incentives displacing Puerto Ricans, harming residents, and the environment. They are labeling this act as another form of American colonialism, especially considering Puerto Rico's current status as a territory of the United States that leaves most decision-making about the island up to the US. Many celebrities and wealthy individuals have been accused of taking advantage of Act 60 for the sake of avoiding higher taxes. Therefore, while some argue Act 60 was created to help the Puerto Rican economy, others are interested in exploring what Act 60 accomplishes, if any benefits outweigh the potential harm being done, and if Act 60 should be changed. So this was a central theme to my article. A major component to this is topics of American colonialism on the island. For example, many Puerto Ricans have been evicted from their homes due to rising housing prices, even in more rural areas. Considering cash payments are viewed as more desirable than mortgage payments, opportunities for Native Puerto Ricans have become more limited, resulting in evictions and displacement. In order to combat this gentrification, protesters have been utilizing slogans such as Puerto Rico no se vende, which translates to Puerto Rico is not for sale in English. This was a major piece of evidence that helped lead me to my conclusion because it demonstrates a direct negative impact onto Puerto Rican residents. Furthermore, these aspects serve as more examples of American colonialism still lingering today in Puerto Rico. Puerto Rican artist Bad Bunny actually addresses this issue in his music video and documentary featuring journalist Bianca Graulau. This music video was also something I wanted to address in my article because it demonstrates how relevant the issue of gentrification is in Puerto Rico and why it is so important to bring awareness about it to the general public, especially in the United States. Another element I wanted to include was access to Puerto Rico's beautiful beaches. Activists have also been concerned about beach access being concentrated in the hands of wealthy investors instead of being shared with native Puerto Ricans. While Puerto Rico's beaches are intended for public use, many are blocked off by these wealthier residences, which forces individuals to go through dangerous paths, such as climbing over rocks to reach the beaches. This was another major piece of evidence that led me to my conclusion because I don't believe that Puerto Ricans should have to put themselves in harm's way in order to access what should already collectively belong to the public. Considering how, according to some, the current system does not benefit everyone and harms both the local community and the environment, there is a need for change, which is why I chose this topic. When writing this article, I wanted to prioritize the opinions and experiences of Puerto Ricans and how Act 60 has impacted them and their daily lives. Therefore, I prioritized researching quotes and stories from Native Puerto Ricans themselves. I also found the topic of Act 60 to be particularly interesting due to its correlation to other events that have occurred recently in Puerto Rico, including Hurricane Maria, which devastated the island and killed about 3,000 people. After this hurricane, the island was not given much of an opportunity to rebuild, and everyday people could not afford to reconstruct their homes or their land. However, the foreign investors had the financial privilege to do so, which further enabled their benefits on the island while displacing native Puerto Ricans. Another element I had briefly included was the corruption of government officials on the island. Many of the officials received monetary benefits and campaign donations in exchange for supporting and upholding Act 60. My family is from Puerto Rico, so this is an issue that I am particularly interested in. Therefore, I wanted to write this article to share more information about what has been going on in Puerto Rico with Act 60 and raise more awareness about it, because a lot of people may be unaware of what it is and its implications for Native Puerto Rican residents. So that concludes my presentation, and thank you so much for having me.
Well, thank you for presenting, Aaliyah. If anyone has any questions regarding Aaliyah or her topic, please feel free to ask again in the chat. We really appreciate the analysis in Act 16 and the multi-layered, I think, components you touched on there. It's a lot of what the value undergraduate law review writing can bring in terms of raising awareness among undergraduates and providing, I'd say, a platform for you to kind of verbalize and share these insights. So again, wonderful, wonderful presentation. Thank you. We're now going to move on to Shreya's presentation on the line of succession. Shreya, if you're all ready, we'll get going.
Yes, thank you so much. So my article was about the line of succession from the British monarchy. So just to give everyone some background on the British monarchy, it originally started out as a heptarchy, or land which is divided into 7 kingdoms with 7 different kings. Over time, the 7 kings started looking up to one individual king, and that is how the monarchy emerged. So my article is mostly focused on the line of succession, which is basically who the throne passes on to in the upcoming generations. So the rule originally started out as a male dominant primogeniture, which means that males got preference to the throne over the females in line. For instance, if the line of succession included a female who had a younger brother, the younger brother would get the throne before the female in line would receive it. At this time, along with the primogeniture-based monarchy, the parliament and the Act of Settlement also controlled who was able to inherit the throne. The Act of Settlement did not allow any Protestant descendants or Catholics to inherit the throne, which limited who inherited the throne more. The male preference primogeniture was changed after the Succession to the Crown Act was created in 2013. This act gave women equality and allowed the throne to be passed down to women, even if she had a younger brother or anything. There was no basis of male preference. It was only birth order based. This is the rule that the British monarchy currently follows, and the current line of succession, as you may know, would be after King Charles would be his son William, and then William's firstborn, and then William's secondborn. I chose to write this article because I recently did a study abroad program at BU last summer in London, and this was right before Queen Elizabeth had passed away, and the British monarchy was highlighted in almost every article and every news channel that we had even opened. So I wanted to address this topic in a way and address the facts about the monarchy as a whole. Thank you so much for giving me this opportunity to speak.
Well, thank you for sharing. If anyone has any questions regarding Shreya's article, again, please feel free to ask directly in the chat. It's very nice to see such an unconventional topic of international law, and specifically monarchies, being touched on in an undergraduate law review. I know many of us have had plenty of social media exposure to the events regarding that succession, but it's really interesting to see that perspective and someone advancing an original legal argument through that. With that in mind, I think we're going to let Katz take it away to introduce the Columbia Undergraduate Law Review and the notes they'll be sharing.
Okay, thank you, Tom. Okay, so the next line of notes that will be presented today are from the Columbia Undergraduate Law Review, and the first one is going to be, I believe this one is by Alicia.
Okay. Hi, my name is Alicia. I'm going to be presenting on the Sackett v. EPA case. So essentially, my article kind of focuses on the Supreme Court case, Sackett v. EPA, which was heard recently in October by the Supreme Court and is now awaiting a ruling by the court, either in favor of the Sackett family or the Environmental Protection Agency. And so I'm essentially trying to answer how should the court rule based on environmental legal precedent, as well as the protection the Clean Water Act offers. The conclusion that I reach is that the Supreme Court should rule in favor of the EPA due to a number of reasons, which I'll get into, but essentially that the environmental precedent that has been established with past cases, as well as sort of the Clean Water Act and its wording really supports a ruling in favor of the EPA. For context, so this case directly questions whether adjacent wetlands are protected by the Clean Water Act. And so the Sackett family, they live in Idaho. They bought property in Idaho that is 300 feet from Priest Lake in Idaho, which is officially deemed a navigable body of water, which means it's protected by the Clean Water Act, like no questions asked. Their property, as I mentioned, is 300 feet from this lake, and they have wetlands on their property. The wetlands on their property are not technically surfacely connected to the lake, but the wetlands scientists have shown are connected sort of through underground means. Essentially, there is a road in between the wetlands and a tributary, and the tributary directly flows into the lake, but the wetland connects underground to the tributary. And so the Sacketts tried to build in 2007, I believe, on their property, and the EPA said, no, you can't, we're not giving you a permit. These wetlands are protected, and the Sacketts are essentially trying to sort of appeal that decision by the EPA. And so for context, the Clean Water Act, it protects wetlands, like in wording, it protects wetlands if they are adjacent to a navigable body of water, which can also be defined as waters of the United States. And in its specific wording, which I believe was added in like about wetlands in amendments in the 1990s, it says that wetlands, to be adjacent, they do not have to be physically touching the navigable body of water. They just have to somehow be connected to that body of water, or just like there has to be proof that these wetlands, that the water that is there is somehow going to end up in the navigable body of water at some point. And so sort of the arguments that I point to and sort of the reasons why I believe that there really is legal standing for the court to rule in favor of the EPA is, one, if you look at the historical application of the Clean Water Act, the sole purpose of the Clean Water Act is to protect waters in the United States from sort of being contaminated, reducing the water, like from the water quality being reduced and such. And so if the Sacketts are to build on their property and build on the wetlands, the construction is inevitably going to release toxins into these wetlands. It's going to contaminate these wetlands, and these wetlands are connected to the lake. Those contaminants will eventually enter the lake, and therefore that kind of goes directly against the sole purpose of the Clean Water Act and why Congress put it into place. Secondly, I point to the modern definition of adjacency, which I sort of got into and described a little bit previously, but the wetlands do not have to touch the body of water to be protected. And these wetlands don't, but they can still be protected, and there is the standing for them to be protected. They're not just very far removed. They're very much connected to the lake. And then also, if you look at past precedent, like cases, one specifically that's really relevant to how the court may rule is a case called Rapinos versus United States. And I'm not going to get into the specific details, but essentially the ramifications of this case are what's most important. The court was kind of divided in a 4-1-4 ruling. So essentially, with the opinions written, there were two different tests that were left that people can put into place on determining whether wetlands are protected or not. So one is called the significant nexus test. And with this test, the wetland just has to have a significant nexus in one way to the body of water. So like this would apply to the Sacketts property because in some shape, way, or form, that water is going to enter the lake at some point. The other test is sort of based on the surface connection, and it's saying that for wetlands to be protected, they have to be surfacely connected. So like the wetland has to directly flow into the lake and has to be visible from the surface. The ruling in Rapinos left it so that they didn't pick a test. They said, these are the two tests. You can choose which one to apply when you're giving a permit. And so with the Sacketts, the Army Corps of Engineers decided to go with the significant nexus test, which they have very much legal standing to do so. And so that's essentially the reasoning I give for how I get to my conclusion. And I think some of the important ramifications to look upon are if the court rules in favor of the Sacketts, a lot of environmental regulations at stake, because they're essentially saying that EPA really can't regulate some of the most important bodies of water and contamination, and it can lead to further environmental degradation, especially in the wake of the recent West Virginia ruling. It's just further going to strip the EPA from their regulatory ability, and their sole purpose is they're there to protect the environment. So it's really important to look at where this case is going to go and how they're going to rule, because it's incredibly important in terms of environmental regulation and legislation. But yeah, that concludes my presentation. Thank you so much.
Great. Thank you so much. Yeah, that was very interesting, especially the ability that like you can use two different tests and that it's kind of up to, the governing bodies about which tests they want to use in that specific instance, especially surrounding environmental law. I know that we personally have seen a lot of notes come out about that. And we've also seen specifically like notes regarding the right to effectively like change the course of a river out west is one I've seen a lot, and like the water rights that are connected to that, and whether or not how you change the river leads to certain people having more access to water than others. So it's very interesting, obviously a little bit different than what you presented, but nonetheless related. So thank you very much. We really appreciate that. That was a great presentation. Okay. Next, we're going to have a little bit of a transition to something a bit more modern regarding the metaverse, and it's going to be presented by Shreya.
Thanks, Jonathan. Hi, everyone. My name is Shreya Shivakumar, and I'm excited to present on my article called Metaverse, the End of Privacy as We Know It, which was published in the Columbia Undergraduate Law Review online journal in spring of 2022. Writing for the CULR allowed me to discover my interests at the intersection of technology and the law. Specifically, last year in the fall, I worked on an AI law roundtable article working with Cambridge University students to write about how the legal implications of emerging AI technologies could be adapted to existing laws. And learning about the differences in the privacy legal frameworks between the EU and the United States really inspired me to think about the metaverse and what it could mean for the future of data privacy rights in the US. The metaverse is a proposal for a network of 3D virtual worlds where people can interact with others. And my article demonstrates how the metaverse could pose unprecedented challenges to user privacy on multiple fronts. For case precedents, first, I discussed the District of Columbia v. Facebook decision, which is an early indication that states' consumer protection laws could be applied to data privacy issues. In the case, a court ruled that the DC Consumer Protection Law could be used to hold Facebook accountable for its irresponsible data handling practices that had a tendency to mislead its users in the Cambridge Analytica scandal. I also predict that the metaverse would involve collection of personal and location data, as well as biometric information, including users' eye movements and other vital signs through the wearing of AR headsets. While there's no federal guidance on this topic yet, the Illinois Biometric Information Privacy Act, or BIPA, offers guidance for future federal legislation in the sphere. Next, I analyzed the ACLU v. Clearview AI case, which is a lawsuit against facial recognition company Clearview AI that alleges violations of the BIPA. In the case, the ACLU alleged that Clearview AI used facial recognition technology to capture face prints without individuals' knowledge or consent. And I use these cases to analyze how courts will rule in the future if similar actions are brought against Meta for violations of privacy rights in the metaverse. I go on to discuss how these precedents could affect regulations for the metaverse, either by the company itself or by the government. As per the ruling in Enre Google Inc., actual consent can be explicit or implied, but must entail disclosures that explicitly notify users of the relevant data handling practices. Meta should have to adhere to the standard, either by self-regulation or by federal privacy legislation, which I advocate for later in my article. Additional users of the metaverse will interact via digital avatars, and they face the possibility of personal data theft by other users in the metaverse. The potential for interaction with AI bots and other creations in the metaverse create a whole host of privacy issues that must be contended with in future legislation. I use the California Privacy Rights Act, or the CPRA, to demonstrate that potential amendments to federal privacy laws to regulate the metaverse should address the collection and handling of data while placing a special emphasis on children who are poised to use the metaverse and are particularly vulnerable to data exploitation. I concluded the current privacy legal framework in the US is unsuited to govern products of present-day technological innovation, such as the metaverse. And I emphasize the need for comprehensive federal privacy legislation to protect data privacy rights before the metaverse becomes a part of our daily lives. I'd like to thank my editor, Mariah, and lead editor, Beatrix, as well as COLR EIC's Mrinalini and Joanne for making this article possible. I'm sure that the metaverse will force us to confront many unexplored legal frontiers, and I hope that those who read my article will appreciate pondering these unlimited possibilities as much as I enjoyed writing about them. Thank you so much.
Thank you. That was a very interesting presentation. We've seen a lot of more contemporary articles, especially surrounding technology arising recently, but the manner in which you delve into privacy issues is very unique and different, and we thought that's very interesting. Specifically, also the fact that you brought up children and the fact that children are now going to be involved. Obviously, we know kind of the rise of like iPad kids or children that are effectively raised on technology, and to think that now there is a potential for children to effectively be raised in augmented reality or within the metaverse, and to see the privacy implications of that in the future is going to be very interesting. So thank you very much. Very interesting. Okay, next we're going to be transitioning to our next note. Please correct me if I'm wrong, but it should be by Sharir and Karen. Are you both here?
Yes, it's Karan.
Karen, sorry about that.
Great. Well, thank you, Jonathan. Good afternoon, everyone. Our article is entitled Raising the Temperature, Analyzing the Implications of the Major Questions Doctrine in West Virginia v. EPA. CULR's print writing program team, composed of myself, Adeline Larson, Karan Parekh, and Kendall Sila, wrote this work during the influx of landmark Supreme Court decisions issued in the summer of 2022. We wanted to write our article on a current decision, and we also wanted to focus on environmental law, which is relatively underrepresented as a topic in our journal. With both of these in mind, we found it apt to write about West Virginia v. EPA, which is one of the most important Supreme Court cases decided in 2022.
This case was particularly important because of its introduction of the major questions doctrine into the lexicon of the Supreme Court. The major questions doctrine is an extension of the non-delegation doctrine and outlines the existence of a set of major questions of such vast economic or political significance that it's simply not enough to defer to agency expertise, but rather requires explicit congressional authorization for certain administrative action. While the ruling did not significantly curtail the EPA's ability to combat climate change, we argue that it has harmed the agency's ability to regulate carbon emissions and has significantly impacted the tools available to federal agencies in future cases. We outlined the details of the court's ruling and the majority opinion, which argues that the EPA's decision to shift electricity production to sources that emit less carbon dioxide, which they justified through their interpretation of the Clean Air Act, violates the major questions doctrine because they did not have clear congressional authorization to regulate carbon emissions.
Our main argument, however, is that the arbitrary invocation of the major questions doctrine, which primarily focuses on vast economic and political consequences as a factor for decision-making, has opened a legal Pandora's box that leverages judicial activism over agency expertise and flexibility. We focus on the origins and evolution of the major questions doctrine, as well as its clear violation of the Chevron deference doctrine, which stipulates that if a congressional statute is silent or ambiguous on a given issue, the court should defer to an expert agency's response, so long as it's based on a permissible or reasonable interpretation of the statute. Instead of Chevron's two-step process, which firstly involves determining statutory ambiguity, and secondly, determining the reasonability of an agency's interpretation, the court rather has a new step zero application of the major questions doctrine. This makes the major questions doctrine both a factor in and an exception to Chevron analysis. This lack of definitional clarity is dangerous because the vagueness grants power in court interpretation. We argue that the hampering of executive agency flexibility can spill over to other issues, such as SEC's climate risk disclosure rule, which would require public companies to disclose climate-related financial statement metrics in periodic statements as a means of investor protection.
We then turned to alternative methods of action needed to combat the climate crisis and achieve meaningful environmental progress. During the writing of this article, Congress passed the historic Inflation Reduction Act, which unlocked hundreds of billions of dollars to invest in technology and infrastructure needed to combat climate change. The bill is particularly important because the Supreme Court's majority opinion cited legislative inaction around climate change as a reason for invoking the major questions doctrine. We argue that the public and private symbiosis for both at an international, national, and state level is essential to reach ambitious climate goals that the United States has set out for the next decade.
With a court whose majority prides itself on its natural conservatism and textualism, such an arbitrary judicial canon like the major questions doctrine challenges the court's commitment to textualism and, as a result, their legitimacy. This constraint on agencies' speed and flexibility will prove to have dangerous consequences for agencies that, despite having experts in their field, must wait for congressional direction that is often hampered in times of political gridlock. Despite this somber outlook, there remains hope. With enough united yet balanced action, society can still confront the largest existential challenge of modern times while preserving the fabric of democracy. Thank you.
Thank you both very much. There's a very interesting analysis. I know that we've had a few notes on the case of West Virginia v. EPA, but you had a very interesting nuanced approach to it, a very in-depth and thorough analysis, especially in relation to the major questions doctrine. And it really overall presents an astounding note on an area, most obviously being environmental law, that I would fully agree with you, often does not get as much exposure as it really deserves to be. So thank you both for your presentation. Very interesting note.
Yes, thank you for your very spectacular co-authorship. It's definitely an interesting topic, and we're excited to see what you guys will write next. But with that being said, we're going to proceed on into the George Washington Undergraduate Law Review, which will be showcasing one of your writers, Samantha Lee. When you're ready, feel free to take it away.
Hi, everyone. My name is Samantha Lee, and I wrote a note titled Intellectual Property Laws in the Fashion Industry, the Legality of Fast Fashion. So as context, the luxury fashion is typically regarded less as a piece of clothing, but as a unique way of expression and in some cases art. For example, Dior's creative director discussed the process beginning from her first inspiration to presenting the dress on the runway. Seamstresses at Dior's atelier spend 3 to 4 weeks to hand embroider flowers and other designs onto the gown. Moreover, instead of using tulle, the traditional fabric that's used, when designers want to embroider, Dior's creative director chose fishnet, which is much more difficult to work with because it better represented her inspiration for the show. In contrast, fast fashion is an all-encompassing term used to describe a business model based on copying and replicating high-end fashion designs and is mass-produced at low cost. However, since fashion law is a patchwork of laws that is primarily based on the Copyright Act of 1976 and the Lanham Act to attempt to create design protection, this combination of laws enable fast fashion companies to take advantage of luxury brands' creativity and innovation because it makes it difficult to decipher what precedents and regulations can be applied to fashion design. The lack of legal protection allows fast fashion brands to proliferate. Because copying designs is in and of itself not illegal, fast fashion brands have incorporated intellectual property lawsuits into part of its business strategy. Significantly, exact or similar replications of an original design by a luxury fashion house decreases the design's aspirational value or the uniqueness of the product. Luxury fashion houses spend an inconceivable amount of effort into inventing, designing, creating, and then launching their products. When cheaper and poorer quality imitations are mass-produced, this causes the design to become widespread and thus associated with a less exclusive, prestigious image and discounts the designer's creativity. Although some critics may argue that counterfeit luxury items serve as an advertising tool and thus benefit the creator, counterfeit versions ultimately dilute the original luxury design and harm the luxury fashion houses that created it. Although my note argues for greater, if not adapted, intellectual property laws for the fashion industry, there are two counter arguments I would like to address. The first is the piracy paradox that was introduced by two professors in 2006. Greatly abbreviated, the piracy paradox aimed to explain how copying functions as an important element of, and perhaps even a necessary predicate to the apparel industry's innovation cycle, and that the ability to legally copy enhances the industry. While fashion is cyclical and luxury fashion houses have produced similar designs, there is a difference between interpretational copying that follows or draws inspiration from popular trends versus an exact or close replication of original designs. Further, the piracy paradox has not taken into account the current technological advances. Now, once designs debut on a runway, fast fashion pirates can use photographs of catwalks to produce copies before the real items are introduced into the market. Replications are often imperfect substitutes, and it could be argued that this does not impact luxury fashion houses, but it's difficult to determine which consumers who bought the pirated item would have been willing to pay a higher price for the original. Another argument against greater fashion intellectual property is that many luxury fashion houses aim to settle cases with fast fashion brands rather than moving to trial. Despite the difficult legal process, luxury fashion houses have proven that if their designs are substantially threatened, they will move forward to prosecute the defendant. Therefore, while many cases do end up in settlement, this does not equate to a luxury fashion house's unwillingness to pursue litigation and should not be used as justification against greater fashion law. One potential way to mitigate the concerns fast fashion poses to luxury fashion houses is by incorporating EU fashion law, specifically the sui generis protection, into the US. This design protection system established a two-tiered approach. The first is the unregistered community design protection that begins with a design's first disclosure into the community. And the second is the registered community design protection after registering with the Office for Harmonization in the internal market. Critics argue that although legal protection is greater in the EU, there's little litigation in Europe involving fashion designs, and there is the same widespread fashion design copying in Europe as there is in the US. The low number of registered designs and case law related to fashion intellectual property does not necessarily equate to a designer's disregard for enforcing their rights, as many cases in Europe reach confidential settlements. Furthermore, given stricter fashion intellectual property laws in the EU, fast fashion retailers who hope to market in the EU need to create derivatives of trends before manufacturing them. Another way to mitigate concerns that fast fashion poses is by encouraging more sustainable fashion, which decreases the potency and viability of fast fashion companies. One way to encourage this is through stricter labor laws that aim to prevent worker exploitation within a company's supply chain and stricter sustainability laws. However, domestic challenges may prevent any policies inspired by the sui generis system or more stringent sustainable and labor laws from being enacted. Thus, a potentially more realistic way to have greater intellectual property protection is through the discretion of the judicial system. So, as counterfeits pose a credible danger to luxury fashion houses, greater intellectual property protection is needed to resolve this challenge. Thank you so much.
Thank you, Samantha. That was a wonderful presentation. We're glad to see more legal analysis of the fast fashion and fashion industry in terms of intellectual property. We've had writers ourselves in the Fordham Undergraduate Law Review inspect this area, but we really appreciate such a high level engagement with it, and we're excited to see where your publication will go next with this topic. With that being said, I think we'll be wrapping up the George Washington Undergraduate Law Review, and we'll be able to showcase some of our own homegrown law review authors. We're going to start off with Jack Hayes, who has just been recently published in last semester's issue, and we're excited to see your presentation, Jack. Feel free to take it away when you're ready.
All right, thank you. My name is Jack Hayes. I am a junior at Fordham University studying political science. I wrote my note on SLAP suits. SLAP stands for Strategic Lawsuit Against Public Participation. These are lawsuits that are not intended to particularly seek an actual legal remedy or argue a question of fact. Rather, they merely seek to use the process of litigation as a weapon against their critics. And that is because litigation is traumatic, it's lengthy, it's tiring, but most of all, it is expensive. And the threat of spending all the money on going to court or spending all the time in court is often enough to discourage people from speaking out against powerful individuals. This has dangers for both the public and the court. For the public, it has the danger of eroding First Amendment rights to redress the government for grievances, but it also has dangers for the court in two ways. One, it crowds out the court of cases that may take more precedence over these SLAPP suits, and it diverts the court's attention away from these oftentimes more important suits. And on the other hand, it threatens the legitimacy of the court because these courts, through the process of forum shopping, are turned into courts that are associated with celebrities airing their dirty laundry or becoming SLAPP courts or becoming defamation courts, which hurts the legitimacy of the court in the eyes of the public. I became motivated to write about this topic after watching the Depp v. Heard trial this past summer, but this is not the only instance of a SLAPP suit. There's many others. For example, John Oliver was sued by Robert Murray after criticizing his coal mining practices. Barbara Streisand sued a photographer after one of the tens of thousands of images of the California coastline contained a photo of her house in it, and it actually ended up bringing more attention to her location, which is now known as the Streisand effect. Tom Martino is a consumer advocate on the radio. He criticized a personal watercraft dealer for their poor customer service and got sued by that watercraft dealer. Johnny Depp received some discussion over anti-SLAPP laws or the lack thereof in Virginia. Devin Nunes sued a few journalists for reporting on some questionable business practices of his. These last two instances are interesting in that they're both instances of forum shopping. Johnny Depp and Devin Nunes both sued in Virginia, which has a deficient anti-SLAPP law compared to the states in which they live. And because of that, this is considered forum shopping because they went to a jurisdiction that would be more friendly to them and less likely to dismiss their case. There are a lot of states that have anti-SLAPP laws in place. As you can see on that graphic, there is a lot of green there, which shows that the Uniform Law Commission has determined that they have sufficient anti-SLAPP protections, but there is a lot of ambiguity. There is a lot of red on there as well. Meaning that through the process of forum shopping, certain states become inundated with these cases. There are existing protections, however, that do somewhat of a job at protecting against SLAPP suits. Rule 11 of the Federal Rules of Civil Procedure punishes attorneys for pleadings presented for any improper purpose, and the Noor-Pennington Doctrine by the Supreme Court grants antitrust immunity to parties petitioning the government to adopt laws that could be considered anti-competitive. The problem with Noor-Pennington, however, is the Supreme Court has chosen to only use it in antitrust cases, whereas other courts have chosen to extrapolate the doctrine to the First Amendment. The issue then that arises is when one goes to court, if they're wanting Noor-Pennington to be used, it's sort of wishful thinking because it depends on the way the judge feels about that particular doctrine. Thus, the need for a more uniform anti-SLAPP law across states or on the federal level has arisen. And there are challenges associated with anti-SLAPP laws, however, and that is balancing the protection of the court and the protection of the public, while also not shutting out good faith claims that ask true questions of fact. The way in which one would fix this, I argue in my note, is balancing the burden between parties so that the anti-SLAPP motion does not become a motion that is just handed out indiscriminately and actually requires work on both parties to show that they either are facing a SLAPP suit or that they are bringing about a suit that is not a SLAPP suit. The Uniform Law Commission has proposed the Uniform Public Expression Protection Act, or the UPEPA. Hawaii, Kentucky, and Washington State have enacted this law. 5 other states are in the process of moving it through their legislatures. It provides a phased approach to the anti-SLAPP motion, requiring first the moving party to prove that they are facing a SLAPP suit. Then the responding party must prove that they have established a prima facie case. And on the third phase, the moving party showing there is not a cause on which relief can be granted or that there is not an issue of fact to be determined in the trial. The prevailing party gets legal fees in this instance, which ultimately leads me to argue that the UPEPA would be an ideal uniform law to reduce the ambiguity between states and anti-SLAPP laws and thus discourage forum shopping and thus protecting the legitimacy of courts in the eyes of the public. And also on the federal level, if the federal government were to choose to enact a federal anti-SLAPP law. And ultimately, my note argued that the UPEPA is an ideal framework for the implementation of a more uniform anti-SLAPP law. But yes, thank you so much for this opportunity.
Thank you, Jack. Wonderful presentation again. Jack's note is not currently available through our website. However, it will be ultimately published alongside Volume 6, Issue 1. We encourage all of you throughout the next year, as we kind of collaborate as undergraduate law reviews, to keep an eye out in Fordham and see Jack's note in its full. It's a wonderful piece of writing, and it's definitely an interesting topic. I'm sure many of you were following contemporary issues of SLAPP lawsuits last summer. So it's exciting to see that in undergraduate law review format. But with that being said, we're happy to now showcase Eli Solomon and his note on youth incarceration and the legal environment surrounding that. Eli, if you're all ready, I'm happy to hand it off.
Thank you. Good afternoon. My name is Eli Solomon, and the note I'm presenting today is An End to Unregulated Juvenile Solitary Confinement, the Need for a Second Chance. Now, to begin, I'll explain the main argument in my note, which is that unregulated juvenile solitary confinement as a practice is unconstitutional per the 8th Amendment through an originalist perspective, which is a perspective of the founding fathers, the time the Constitution was written, and a contemporary Supreme Court perspective. To give a little bit of background on what solitary confinement is, it's a punishment where prisoners are taken, usually for disciplinary reasons, out of their cell and put into a smaller, isolated cell, which usually only has a bed, sink, toilet, and a window, though oftentimes the windows are a lot smaller than the one in that picture. The rooms can measure up to 6 by 9 feet or 8 by 10, and prisoners at the most extreme can be keeping up to 23 hours a day at a time, with 1 hour gone, usually being exercise or just getting out of the cell. Now, for the structure of my note, I first went through the originalist perspective, then the contemporary Supreme Court perspective. Then I merged both perspectives and argued from both the cruel and then the unusual. So I'll begin with the originalist perspective. I argue first for the part of the 8th Amendment for the punishments clause. The punishments clause is the nor cruel and unusual punishments inflicted part of the 8th Amendment. So the cruel and unusual punishments clause was taken from the English Bill of Rights, as was most of the 8th Amendment, and the English Bill of Rights was under the English common law. Now, the English common law works off of precedent, and with a precedent, it means that the laws gain legitimacy over their long usage. And with the long usage, that made the laws be seen as usual. Then, on the contrary, laws that weren't considered to be used for a long time were contrary to long usage and were therefore seen as unusual. Now, because a lot of the people going to America at the time, a lot of the colonists were from Britain, the common law was kind of like transferred over and it had legitimacy. Therefore, this meaning would have been also used in America. Now, for cruel, at this time, in the two leading dictionaries, it had two different meanings. One of them was taking delight in causing pain, which legal scholar John Steinford notes as cruel intent, and another one, it was harmful, inhumane, and barbarous, which Steinford notes as cruel effect. Now, a lot of the case law at this time stuck to this reading of cruel in the cruel effect definition. Merging these two definitions now, we get a reading that the founding fathers might have had of the punishments clause as prohibiting punishment that was unjustly harsh in the light of long-standing practice. Now, this kind of differs with in light of the contemporary Supreme Court decision, because they don't really have a set definition of what cruel and unusual means. Rather, they base it off of an opinion from a court case, Trop versus Duels, decided in 1958, where the opinion decided that the 8th Amendment had to be read in light of the evolving standards of decency that mark the progress of a maturing society. What do they mean by this? Well, they take those evolving standards from the effects of the punishment, their own thoughts, international legislation, state legislation, and a few other things. Now, that's one part of the cruel and unusual punishments clause, the way the court recognized it. Because solitary confinement is punishment, therefore we must also use Wilson versus Sater's analysis, where confinement must need two conditions to be considered cruel and unusual. The first one is an objective condition, which the deprivation that is caused must be sufficiently serious. And the subjective component, which states that the official that acted was under a sufficiently culpable state of mind. Now, with these two definitions, I'll go into arguing the first from the cruelty perspective and then under unusual. Now, as a refresher, to be cruel under these two perspectives, solitary confinement must be both unjustly harsh, cause sufficiently serious deprivation, and must be enacted with deliberate indifference. But I'll get back to the deliberate indifference in the next section. So the deprivation that I argue is being taken in solitary confinement from juveniles is the deprivation of stimulation, specifically mental, social, and physical stimulation. Being locked up in a room for 23 hours, as might often happen in solitary confinement for juveniles that is unregulated, it's supremely inhumane and harmful to a child's development. There can be several negative effects associated with it. A few of them are depression, lower brain function, hypersensitivity to stimuli, appetite and weight loss, hallucinating. And these effects are not only all felt by adults, but in children, they're felt faster and they're felt in a more severe manner. Now, additionally, in many prisons too, children that are put in solitary confinement are not allowed to talk to their family. Talking to family is extremely important for children, especially when children are developing. Taking them away from not only talking to family, but also from other prisoners completely removes their social stimulation. And that also compounds these negative effects that they're experiencing, which can make their experience even worse. Now, I argue that all these negative effects show that this deprivation of stimulation, the practice itself, is sufficiently serious. Additionally, on top of this, recently there has been doubt casted on the rehabilitative capacity of solitary confinement, especially for juveniles. I know of one study specifically that was done in a prison that determined that there wasn't really evidence that showed that solitary confinement deterred future rule violations. And additionally, one other study that showed that violence didn't actually decrease when solitary confinement was removed as a practice. So from those two studies, I argue that solitary confinement as a punishment has little to no rehabilitative value, which, along with the negative effects, makes the punishment itself unjustly harsh, and it should not be practiced. Moving on to the unusual side, recently the court has linked the term unusual with rarity in comparison to the contrary to long usage definition. So to begin with the contemporary court definition, currently 24 states have no limitations or prohibition on solitary confinement as a punishment. Respectively, 26 states do have some kind of regulations on solitary confinement. Additionally, Obama in 2016 banned solitary confinement for juveniles in federal prisons. And then additionally, there have been international legislations such as the UN Nelson Mandela rules and a report by the UN Special Reporter on Torture that have both called for prohibiting solitary confinement for juveniles. Now, on one hand, we can take deliberate indifference from this on an institutional perspective and say that not only prison officials, but the prison systems and people who run prisons should be aware of this. And they should also be aware of the scientific and psychological studies that show the multiple negative effects on juveniles that solitary confinement can have. And therefore, this fits in with this deliberate indifference. Additionally, in 2005, Roper v. Simmons, a Supreme Court case was decided that showed where the judges decided that the direction of change of a policy can determine if a practice falls out of line with the standards of decency. Now, through this, we can say that I argue actually that this falls out of line with the standards of decency, having no regulations on solitary confinement, and rather having regulations or even prohibiting the practice is actually in line with the standards of decency. Moving on to the originalist definition of unusual as contrary to long usage, there was already recognition of the harms of solitary confinement to adults in the 1800s. and it was found to be detrimental to the prisoner's health. And actually, towards the end of the 1800s and into the 1900s, the practice was mostly abandoned by prisons. There were prisons that still used it, but so much so to the point that its usage was actually uncommon. It was contrary to long usage. And I argue that this delegitimized the practice, so much so that when the practice was readopted back in the 60s and up until the 80s and 90s, where it saw great prominence and now inclusion in most prisons in the United States, this use is contrary to long usage. It has not enjoyed long usage in the same way that it once did because it was renewed. Now, to conclude, I just want to say that I believe that solitary confinement is, as long as it is unregulated, is antithetical to rehabilitation, and if not complete abolition of the punishment, limitations must be placed in order for an actual responsible, in order for the punishment to be responsibly practiced. Thank you.
Thank you, Eli. Very nuanced, interesting presentation of your legal research. As I am kind of representing the editorial board here, I just like to extend Eli put a sincere amount of effort into his research in the different areas of law and jurisdiction he had to engage with. Just a really high level of research there. So thank you, Eli. But with that being said, I'm going to hand off to Katz at the moment, who's going to showcase the writers from the Virginia Undergraduate Law Review. Katz, if you're ready to come.
Yes, I'm ready. Okay. Yes, thank you. I just have to say, Jack and Eli, obviously, since you know, slight favoritism towards them, but obviously I love everyone here equally. Next up, we have the Virginia Undergraduate Law Review, and they will actually be presenting 2 notes from their inaugural edition. I believe that Virginia, I believe you are the youngest of the law reviews. I had actually remembered last year, I believe one of the members of your editorial board reached out to us about your original incorporation, which was very interesting. So it's very interesting that last year you were talking to us about, oh, how do we go about establishing an undergraduate law review? And now you're here to present 2 notes on your inaugural edition. I believe that we will be starting today with Jack.
Thank you, Jonathan. I'm very, very proud to be a representative of the newly reformed Virginia Undergraduate Law Review. We've put a ton of effort over the past publications we can be proud of and building a community of law-interested students. And I'm sad to say that there are only 2 of us presenting today because I'm really just proud of everyone who I've been able to work with for the past few months. My article is called The Gray Areas of Dobbs, Brown, and Stare Decisis, What Can't Be Overturned. And as is implied from the title, it concerns mostly the Supreme Court's doctrine of stare decisis, a Latin term, of course, meaning to stand by things decided. The Supreme Court has, over time, built a massive, massive pile of precedents that it uses to decide its current cases. And according to the doctrine of stare decisis, it rarely overturns those cases, even if it believes they're wrong, unless it has a special reason to do so. I'm looking at this doctrine in my note, mostly through the lens of 2 areas of jurisprudence. First, the landmark Brown v. Board of Education, as we all know, the largest case and most well known in the Supreme Court's history to overturn precedent, as well as through the lens of abortion jurisprudence, which has been surprisingly influenced by stare decisis. Throughout several cases dealing with abortion, especially Planned Parenthood v. Casey, and of course the most recent Dobbs v. Jackson Women's Health Organization, we see an intense discussion of this doctrine of stare decisis, especially the factors in its consideration that have changed over time. I would argue that, like the other landmark cases released in the summer of 2022, Dobbs v. Jackson Women's Health Organization embarks on a significant activist streak by the Supreme Court, which wants to achieve ideological goals rather than preserve the ideals of precedent, rely on previous decisions, or even adhere to the textualism that it claims to support. I look at this mostly through consideration of the stare decisis factors considered first in Planned Parenthood v. Casey, which are, in no particular order, changed facts? Have the material facts and constitutional considerations to the case changed in the intervening years between the original case and the case being reconsidered? Second, remnants. Does the original case represent a consistent application of jurisprudence with the cases that deal with similar concepts, or has jurisprudence evolved over time away from that case? If so, that remnant ought to be overturned or reconsidered. We also consider reliance interests. Do people have a significant dependence on the Supreme Court decision originally staying the same? For example, have people established contracts or monetary relationships based on that decision? But also, Planned Parenthood v. Casey considered a type of reliance interest that is conceptual. For example, in the field of abortion, women have organized their lives around the ability to continue their career or have successful personal relationships based on the dependence on not having an unexpected pregnancy and having to carry it to term. These are considerations that the Supreme Court made in Planned Parenthood v. Casey. But we also see that these considerations change significantly over time between 1993, when the court upheld Roe v. Wade, and 2022, when the Supreme Court overturned it. For instance, Justice Brett Kavanaugh introduced in a concurrence in 2020 to Ramos v. Louisiana a consideration in stare decisis of the erroneousness of the decision. Specifically, he said that the Supreme Court should consider whether or not a decision is a garden variety error, and that garden variety errors ought not to be overturned, only egregious ones. But this, to me, represents a significant departure from the ideals of stare decisis. This isn't a special consideration outside the merits of the case, but rather a subjective judgment on the judgment of previous justices, and an infringement on this ideal. Justice Lewis Powell remarked in 1973 that without stare decisis, the Constitution would be exactly what 5 justices say it is. And this consideration of the erroneousness of the decision, combined with another factor that Dobbs v. Jackson considered, which is the quality of the previous case's reasoning, we see that the Supreme Court is embarking on a journey to make the Constitution exactly what the new conservative majority claims it to be. And I see that there are significant threats to the future stability of the Constitution from this increasing subjective judgment being placed on overruling decisions and the erosion of the doctrine of stare decisis. Specifically with rights related to abortion, gay marriage, gay sex, the right to purchase contraception, and of course interracial marriage as established in Loving v. Virginia in 1967. These rights all also fit under the word liberty in the Due Process Clause of the 14th Amendment. And intervening cases, which I discuss in my note, put into question the constitutional legitimacy of these rights being established in this specific part of the Constitution. In fact, Justice Clarence Thomas, in his dissent to Dobbs v. Jackson, in his concurrence to Dobbs v. Jackson, argued that all of the 14th Amendment due process rights ought to be overturned. And with the erosion of the doctrine of stare decisis and the very public opinion of several justices against the constitutional right to gay marriage, I'm concerned that they intend to or have laid the groundwork for the erosion of other rights that we consider sacred, especially since now they can overturn kind of whatever they want. So I ask all of my readers, and I really hope you guys do check out my note, what can't be overturned? We must consider deeply the implications of the erosion of our constitutional foundations of precedent, and challenge the Supreme Court's assumption that activism must happen, that the ends justify the means. I am very proud to be part of this publication, and right now I want to pass it off to Mary Kate, who's also got some amazing analysis. Thank you all for your attention.
Thank you, Jack. That was a very in-depth analysis of stare decisis and very interesting approach to what you propose here, kind of the erosion of the Constitution and balancing effectively activism at the same time as, well, really what is legalism and ensuring the foundations of our democracy, of the Constitution, and of the entirety of the judiciary still stay intact as times change, as kind of perspectives and attitudes towards certain things change. And that's something very important to keep in mind, as you stated. So thank you very much. Very interesting note. Okay, next we are going to be moving on to Mary's note about chemical bans.
Hi, everyone. My name is Mary Kate Hogan, and I'm also a staff writer for the Virginia Undergraduate Law Review. My article is called "Some Things Do Last Forever: How Chemical Bans Mitigate a Public Health Dilemma." I am a global public health major here at UVA and super interested in health law, so this topic ended up being a perfect fit. I wanted to start off with a little bit of background information about PFAS, which are harmful man-made chemicals used in the manufacturing processes of many widely used consumer items and household products. These chemicals have already been found in over 95% of Americans' blood and are most often transmitted through contaminated drinking water sources due to the disposal mechanisms of these chemicals into various water sources. PFAS are often referred to as forever chemicals due to their longevity and the fact that they are incredibly difficult to chemically break down. PFAS have recently been linked to various adverse health effects by the CDC, such as cancer, vaccination resistance, damages to the immune system, developmental defects, hormone disruption, and decreased fertility. There are currently no federal regulations in place regarding PFAS, posing concerns regarding consumer protection, environmental effects, and health ramifications. The patchwork method of state-by-state regulations has not been as effective as federal interventions could be in safeguarding American public health. Under both the Safe Water Drinking Act and the Clean Water Act, I concluded that the EPA has the power to intervene by regulating corporate manufacturers who have allegedly been responsible for producing these chemicals, or by establishing a standard national maximum contaminant level for both ground and tap water. I'm so glad Alicia also discussed the Clean Water Act a little bit earlier. Clearly, the government plays a big role in protecting our water sources. As of the past 2 weeks, the EPA, in conjunction with the National Institutes of Health, actually just released a proposal for the first PFAS National Drinking Water Standard. This topic has become much more prominent in the past few years and is getting even more attention right now as more scientific and legal advances are being made. Stay tuned on the topic, as we will hopefully see even more progress coming soon. Thank you.
Thank you very much, Mary. That was a great overview kind of the chemical bans and kind of the ideas that we have to keep in mind as we're balancing that public health dilemma, and obviously kind of at the same time balancing that with human health concerns, but also kind of with the idea that the government and specifically these companies all kind of have their own interests in these issues as we go forward. So thank you for that. We really appreciate that.
All right, thank you very much, Mary Kate. Lovely presentation. We're excited to see what your journal will publish in its second edition. The inaugural edition seems to be at a very high level. We're very, very excited to see that you guys progressed and got to the point of publication. But with that being said, that just about wraps up our note presentations. So I'd like that with our note presentations concluded, I'd like to leave you with a few parting words. This conference, of course, would not be possible without the enthusiastic cooperation between undergraduate law reviews. We appreciate the willingness of the editorial staff from each of your journals in coordinating our writer spotlights. Please know that we're excited to follow your future publications as a result of this. You showcased your research and arguments at the highest possible level. We'd also like to extend a sincere thanks towards our keynote speakers, Judge Lyons and Caroline Morris. We appreciate putting aside the time from your busy schedules to foster legal research at the undergraduate level. As we conclude our second ever Intercollegiate Undergraduate Law Review Conference, I'd like to reiterate the purpose of this event. Through the promotion and engagement of each other's work, we promote awareness of contemporary legal issues. We're encouraged to see both new and returning publications featured at today's conference, and we all hope to see your journals return for future conferences as we continue these relationships. After this meeting, we'll be providing contact information from all of our law reviews. Please don't hesitate to reach out to any of our respective publications for future collaborations or events. And with that being said, that just about wraps up our presentation. So if you have any questions, please feel free to stay behind. We'd be happy to engage with all of you. But that wraps up the second ever Intercollegiate Undergraduate Law Review Conference.
Thank
Congrats,
you,
everyone.
We really appreciate it. It was an amazing conference. Yeah, so I mean, not that the first one wasn't amazing, but I think this is the best one so far. So thank you all for your participation. It wouldn't have been so amazing without you all.